Well, so every property owner has the obligation to keep their property reasonably safe for people that come onto the property, guests or customers, or in this case, students. And that obligation doesn't change in the face of snow and ice removal. So my understanding is that the university does have a protocol for removing snow and ice on the traveled portions of the walkways through campus. So the question is whether they did that in this case, or whether they did that effectively to keep students safe or not. So, and then the other question is, how did she fall and what did she slip on? So there's no question that the university can be held responsible for that. It really comes down to whether their actions or inactions in this case were reasonable or not, and whether they took the appropriate precautions. So for instance, if she was traveling on a walkway that the university knew was popular, traveled frequently by students, and they failed to remove snow or ice like they've done in the past, then that would be a pretty strong case against the university. If, on the other hand, she was walking in an area that was not frequently traveled, or she was off the path, then that would be a much tougher case to hold the university responsible. So these cases are incredibly fact-specific, because the absence or inclusion of a particular fact can make all the difference in the world as far as what the landowner's likely responsibility will be. Sure, I just gave you two examples where she was walking. Another fact might be, did the university have a protocol in place to remove snow and ice? And if so, was it done in this case, or was it adequately done? So if they went a couple of days without following that protocol, then that would make a stronger case against the university. Also in these cases, the actions or precautions taken by the person that slipped have a big impact. So for instance, was she running? Was she acting carelessly, not watching out for her own safety? If there are facts to show that, then that would be a much weaker case against the university. So oftentimes in cases like this, there's a sharing of fault. The person wasn't looking where they were walking, or walking too fast, not taking the appropriate precautions, and the university failed to do enough that it should have done to protect students in this type of weather. Nothing specific. I mean, these cases happen all the time, but it's happened much more frequently on private land. But I think this one is getting much more attention because the university is involved. So anytime you're inviting people, members of the public, to come on your property, either a customer or, like in this case, a student, you have an obligation to keep the property reasonably safe for their travel on your property, and to protect them from known dangers that may exist on the property. So with snow and ice, that's a known danger. Our courts have already ruled that is a known danger. So if you've got a lot of people coming onto your property in this type of inclement weather, then you should have some sort of protocol in place to remove it, or to warn people that come onto the property about its existence. And if you fail to do that reasonably, then you could be held responsible. So oftentimes the big dispute is, what was reasonable? Was it reasonable what the landowner did or didn't do in this case? That's usually a big issue of contention. It's, for instance, if a lawsuit was filed against the university, that would be a question for the jury. So it's based on the facts of that particular case. So if I'm representing the estate of this young gal, I would be looking to see if the university followed its own protocols for ice and snow removal. And if so, how adequate it was. Was the protocol adequate in this type of weather? Was it followed in this particular case? Was it deficient in some way? Oftentimes I'll hire an expert to help me prove whether it was reasonable on the university's part or not, or what they could have done or should have done more to prevent this type of incident. So the other thing that comes up oftentimes is similar cases, similar falls and injuries. How many slip and falls have there been on campus involving snow and ice removal? If there have been a lot, then obviously that makes the existence of some specific protocol that more important, and the fact that it should be routinely followed that more important. So in that particular case, if you can show a long history of prior similar incidences and they failed to follow their own protocol, then that would be a really strong case against the university. They knew about this danger, they didn't follow their own procedures concerning this danger, they knew this type of injury or death could occur, and they didn't do enough to prevent it. Sometimes signs, if the signage doesn't matter. If a student has to get to a particular hall to go to class, and there's only one way for that student to travel, does it really matter if there's signs up? The student has to get to class no matter what. So if they're just putting up signs without removing or doing what they can to remove or melt the ice, then I would argue that's not enough. We want to know where did the fall happen on just the open asphalt area, or did it happen on a particular walkway? If it happened on a particular walkway, then that would be a stronger case, I would think, against the university. Because the walkway is basically the university's way of directing traffic on the campus. If she was on the open asphalt area and she decided to travel on a portion of that area that was heavily covered with snow and ice, and there were other areas that were not, that were clear, then that would be a strong argument against her for walking in an area that she should have known was much more dangerous. And that would result in a much weaker case against the university. So when I say fact specific, that's what I mean. All these different facts come into play to assessing whether the university did what it was supposed to do, did enough to protect its students on campus.